Daghang yung salamat sa atong kinabuhi sa atong adlaw karon og sa kinabuhi nga gihatag nimo sa among kanunay. Unya i-guide me pirmi sa among mabuluhaton and at the same time pod palihog lang kanang bless nato atong kagalingon. Bless us always, especially to our professor sa atong lecturer na si USEC JBJ, and also this we ask kani atong ipangayo pinaagi ni Kristo sa atong ang bugtong anak sa atong amahan. Amen.
Amen.
Sa
Samahan
mahal
sa
sa
anak
anak
sa
sa
Espiritu
Espiritu Santo.
Santo.
Amen.
Daghan kayong salamat, Mr. Dan Carion. Good evening, everyone. And good evening, USEC JBJ. First of all, at the expense of sounding redundant, I would always say this, that our enormous gratitude for the dedication and service of USEC JBJ in holding this lecture every Monday, despite everything that he's been going through, and bisag masakit siya usahay, naagi hapon siya, and we are very thankful for that one. And now, ako ang dakong garbo og dungog ang pag-introduce ninyo karon pagbalik sa ato ang lecturer, the one and the only USEC Josephus B. USEC.
Maayong gabi kadatong tanan. Can you hear me?
Yes, Yusek. Mayang gabi sa
Ang gabi, Sek.
Okay. Today
Evening
is
po, Yusek.
Hoy, maayong gabi diha. Today is the 46th anniversary of martial law. And I can recall that I was then 21 years old, and I was the president of the UV Supreme Student Council. So I think it was a Thursday when martial law was declared, and the university declared a cancellation of classes because 3 days before the announcement of martial law formally, there was a total blackout of all radio station and all TV network, and there was a series of arrests of all opposition leaders, including Senators Tanyada, Jokno, Salonga, and Ninoy Aquino was arrested in Hilton Hotel by General Romeo Gatan. On the 22nd of September 1972, I was picked up by 6x6 in my small shanty, Tipa hut in Bay Rodriguez. I was living in a squatter area as a law student, and I was picked up while I was cooking dinner. And when I was picked up, I requested the military to allow me to put out the fire before they arrest me. And I was taken. And when I boarded the 6x6, I found the other student leaders in Cebu, including the student leaders from CIT, from San Jose, from San Carlos, and there were even those who were in ladies' uniform from Immaculada and Santa Teresa. So that was the beginning of my 49 days of detention in Camp Serio, Osmeña, where by the grace of the Almighty God, I did not feel bitter or angry. In fact, I used the 49 days, 7 weeks as an occasion to be the deliverer of the word of the Lord inside. I conducted a series of conciliar classes inside. I was allowed by the God because it was a religious activity. There were songs because I was concilio of the Lord. That was the reason, one of the reasons I was arrested because I joined
Attorney, I think there's a problem with your audio, attorney. I'm sorry. I'm sorry
Huh?
for interrupting you, attorney.
You cannot hear me?
Kana, attorney. Okay na. Ganiha, hinay siya.
Okay, so uh, I just recall for purposes of recollection of my past when I was arrested. And during the 49 days, I was helping the spiritual needs of the detention prisoners. And also the military officers were attending my religious activity. So after 49 days, I was released because Governor Eduardo Gullas uh, told the general who the commanding general of Camp Serio Osmeña that I'm not a communist. I'm just an activist. And there was no evidence whatsoever that I committed insurrection, rebellion, or treason. There was no war, so there could be no treason. So there was no insurrection, rebellion, not even subversion, because at that time, Republic Act 1700 was still in full, the anti-subversion law, which was abrogated by President Cory Aquino when she assumed office. So I'm just trying to share that with you because the story of my life is that I was really exposed to the danger of the powers of the state. The powers of the state. And then later on, by twist of irony, the president who declared martial law appointed me as labor arbiter, as the youngest labor judge in the whole Philippines. I was the only one coming outside of Manila who was appointed at the young age of 26. I was already hearing disputes on unfair labor practice, illegal dismissal, money claims, and I was also designated by Secretary Oplet to become the inspector all over the Philippines and auditing the performance of all the labor arbiters. So that was the start of my career in labor relations. And so from 1974 up to the present, I have been focusing on labor law. So tonight, that's why one of the reasons why I really served the university because of the help of Governor Gullas. He was still the governor then. And he was aligned with the party of President Marcos. And so therefore his word carried weight that I was not a communist. So I was released, but I missed my experience inside. So even if I was released, I was still invited by them to continue with my religious activity inside the detention center to give inspiration and hope to those who are inside, who were inside. So today, ladies and gentlemen, we will, this is our 17th session. Can you believe it, Attorney Wagas? We have already finished 17th session.
Yes, attorney.
And we are now going to take up one of the most important topic in labor law, which is about unfair labor practice. After we discussed collective bargaining last time, and we discussed the case of Divine Word University, and all the other cases, including the case of Philippine Airlines on CBA moratorium, we will discuss today one of the most important topics in labor relation, which is unfair labor practice. There are many students who are going to take the bar and they have failed to really understand the meaning of unfair labor practice. I would say that not all unfair practices that are committed by management can be considered unfair labor practice. For instance, there is a manager who has 2 employees. One is a very hardworking, productive, shall we say, secretary, 2 secretary. One is a nice secretary, the other is a good secretary. The good secretary was very hardworking, productive, very committed and focused to her job. And the other is a nice secretary. She was just sexy and she does not accomplish anything, but the manager likes her more because she is very attractive. And so when the salary increases were given, my secretary received a very high salary increase, while the good secretary received only a minimal increase. That, my friends, is an unfair practice. But that is not an unfair labor practice, because unfair labor practice is always related to the exercise of the right to join, assist, or form labor unions. ULP, you just imagine that ULP is a virus that attacks 3 major organs of the rights of labor, and these are the right to self-organization, the right to collective bargaining, and the right to peaceful concerted action. The fourth right that is always attacked by ULP is the right to security of tenure. So if ULP is a virus that attacks 4 vital organs of the rights of labor, then the right to strike, which is our topic next meeting, is a weapon of self-defense. The state gives the workers the right to strike as a defense against ULP, because unfair labor practice is an act of aggression. It is an unlawful act, and it is an act of aggression assaulting the right to self-organization. So usually when the workers are in the process of organizing, they are subjected to many acts of harassment, persecution, discrimination, as long as the motive is to resist unionism. If the motive of management is to resist unionism, the action, whether it is dismissal, it is constructive dismissal, or it is an illegal transfer or discrimination, is always an act of unfair labor practice, because the qualifying circumstance that makes an act ULP is the motive, and the motive is anti-union, anti-bargaining. That's why in the case of the Bindward University, the failure of the management, the administration of the university to answer within 10 calendar days was tantamount to refusal to bargain, was tantamount to bargaining in bad faith or violation of the duty to bargain. And therefore, it was an unfair labor practice which justified the strike that was undertaken by the workers. So I think that is very clear that ULP is an unlawful aggression. It is an attack against the right. And therefore, the right to strike, which is our next topic, next meeting, is just a self-defense. It is a defense that is reasonable within the framework of the law, and that is allowed. So if people would ask, why are workers allowed to strike? That is their weapon of self-defense. Because if we allow the employer to undertake massive layoff, massive retrenchment without any abatement, without the interference by the state, so that is an attack against security of tenure. That is an attack against self-organization. If they are in the process of unionizing, that is an attack against the right to collective bargaining. That is an attack against the right to peaceful concerted activity. So, therefore, the topic that we have today is an institution created by law to empower the workers to defend themselves against an assault. That's why strike is not an offensive weapon, it is a defensive weapon. That is the strongest defensive weapon of the workers is the right to strike, because they are being attacked by ULP, and that is our topic. So if you look at our metamorphosis, and we have finished bargaining, number 7. So we are now in number 8, because the workers, the union, are being attacked. The union and the workers are being attacked by the employer through the process of unfair labor practice. Let us understand the meaning of unfair labor practice. What used to be Article 247 is now renumbered as Article 258. So when you look at the screen, it is Article 247. That's the old number. The new number is Article 258. And the Article 248 on the screen, the new number is Article 259. And then Article 250 for 249. So let us now discuss this nature and concept of ULP. Unfair labor practice is one of the few provisions of the labor code which is a criminal offense. If you will be asked by the examiner, can you name provisions of the labor code that are criminal in nature? One is the illegal recruitment in Book 1. Illegal recruitment in Book 1 is a criminal offense. Then you can go to Book 3 on the minimum wage, because violation of minimum wage under Republic Act 8188 is a criminal offense. And it is even punishable up to 4 years imprisonment, no, as maximum. So the third would be unfair labor practice. So others are just administrative cases, but unfair labor practice is a criminal offense. In fact, if you look at the screen, number 1, it violates the Constitution. It violates the Constitution because the Constitution, Article 13, Section 3, enshrines the right to self-organization. And so to assault self-organization, which is a constitutional right, is tantamount to a violation of the Constitution. And then it is inimical to the interests of both labor and management. This is what Article 258, formerly Article 247, provides, that it is inimical to labor and management. It is also inimical to the right to bargain with freedom and mutual respect. When an employer violates the right to collective bargaining, as what was done in Divine Word University, that was considered as not only a violation of the rights of the workers, but also violation of the Constitution. And number 3, it is disruptive of industrial peace. The first 218, formerly 211, enumerates the purpose of labor relation one of which is to promote industrial peace that is sound, just, and dynamic. Now, unfair labor practice is anathema. It is a contradiction to in Article 218, formerly Article 211, first article of Book 5. And number 4, it hinders labor management relations. It is a violation of the civil rights of both parties. And finally, it is a criminal offense against the state. So, because it violates the Constitution. May civil law because it violates the civil rights. Meron pa rin criminal law because it is a criminal offense against the state. Plus the labor law. So, Constitution, labor law, civil law, criminal law, ang bigat ng unfair labor practice. Unfair labor practice is really a very serious offense. And that's why the labor arbiters should give priority to cases that are tainted with ULP. The other illegal dismissal cases are just illegal dismissal. But if the illegal dismissal is occasioned by the process of unionizing, and it was precisely done by management unions, then it becomes tainted with ULP. Later on, ladies and gentlemen, I will discuss the case of General Milling Corporation. And in that case of General Milling, management was declared guilty of unfair labor practice because the records of the case indicate that some managers, some workers to resign from the union. While the union has already presented to the company their for a renewal of their collective bargaining agreement, there were testimonies and other evidence submitted, and it reached the Supreme Court, pointing to the fact that the workers and telling them to resign from the union so that the union becomes minority. And when the union is already a minority, the employer can say, we cannot negotiate with you because you do not represent the majority of the bargaining unit. You must have a certification election. So that restraint, interference, and coercion, which brings us to Article 59, which used to be Article 248, no? 259 na ngayon. At I ask you to memorize this mnemonic device, yung number 1, RIC, R-I-C. Si RIC. Si RIC ay restraint, imong gipugnan or yung pinipigilan mo ang mga manggagawa na nais magtayo ng union. So gipugnan nimo ang mga tao nga napadesider na nga gama sila og usa ka kapunungan nga union. Ang management na using their power, using influence, using their superior knowledge, restraints in whatever manner, no? Whatever manner, no? Sa pagpugong, sa pagdumili, sa pagsalanta, sa pagpakgang, no? Sa pagpaagi nga dili madayon ang unyon sa mga iba-ibang mga paraan. So, restraint is really UL workers from exercising the right which is enshrined in the Constitution and promoted as a state policy in Article 218 of the Labor Code. So, kinakalaban mo yung Constitution, kinakalaban mo yung Labor Code, kinakalaban mo yung karapatan ng manggagawa. So, restraint, pinugnan. Ang pangalawa ng interference, panghilabot. Bystander rule man tayo, ang management, dili man ang ngayang manghilabot, pero kung ang management mangampanya, ayaw magboto ana, ari mo speakas kay gubot kay na mga tawhana. So, interference. Maari gani nga magbutang ang management o ilang kaugalingong kandidato. No? Pwedeng maglagay ang management ng kaugalingon style sa mga panahon pang mga 1950s nga ang mga allegation nga ang Amerika nakikialam sa eleksyon sa Pilipinas. Internal affair of sovereign nation. Nakikialam. Kasi gusto nilang maproteksyonan yung kanilang mga negosyo sa Pilipinas. So magbutang sila o kandidato nila nga dili pahirapan ang ilang negosyo. So ganun din ang management. Maingon union ta din ni sa ato, maayo nang molingkod nga union, nga tao na to. Busa magbutang tag atong interface na tawagon nimo ang mga mobutar yung, uy, kamo ha, dako ra ba mug-utang sa kabubuton sa management kay dagko kay mga cash advance. Ayaw gin magbutar ang pikas. Arigin mo diri sa bata ng interference because according to the bystander rule, the company should have a hands-off policy. They cannot even give. Hindi nga sila pwedeng magsalita nga sana manalo itong isang union. That would constitute interference. And strictly prohibited. Interference is the complete opposite of the bystander rule. It is a complete antithesis to the hands-off policy. Paano ka mag-hands-off na you interfere? Yung coercion naman, yung mga tao na di ko mo butar ma'am kay gubot kayo, maikog ko, doha ka side. Ya, pugson nga na, pugson gyud sa management. Butar gyud kay aron makadaog tong atong manok. That is coercion. When you use yung ikaw ra ba na kay application nga matransfer ka sa maayong posisyon, di masalanta gyud na imong application kung di makadaog ning pikas, no? So those are manipulation of the will. It is yung consent, no, is manipulated through gross misrepresentation, deceit, no, yung pressure, yung mga manipulation, blackmail, no, blackmail. Ikaw ra ba may pending case ka? Tanggal yung kaserbaho nimo. So mao na yung mga paagi sa management nga gidili hugot nga gidili sa balaod, no? Kanang tatlo ha, Rick. Tandaan yun na inyo si Rick, number 1 niya, number 5, number 4 si Ida. Si Rick nasa ibabaw ni Ida. Ano yung Ida? Initiate, dominate, and apelido niya G, no? Initiate, dominate, and assist. In other words, kung ang management mismo ang magtayo ng union para, sabi ng management, we have heard rumor na nakapasok na daw ang KMU sa ating company. Marami na daw mga KMU dito. So bago sila mag-file ng kanilang registration, unahan na natin. Tanang mga bata-bata natin, yung mga loyalist natin, magtayo ng union kaagad. So, if the company itself, by the process of manipulation, is the one initiating creation of union, that by itself is ULT because it violates of policy and it is a clear interference when you initiate. Or when you dominate, in other words, when you dominate, yung presidente ng union na hindi marunong mag-isip, bakit ba pinili na presidente yan ng union? Kasi gwapo, katapos hindi naman marunong magsalita. Basta lang ang mga kauban. Karon gidominate na hinuon siya kaya ang HR manager sugo niya mao ni buhata. So in other words, parang Philippine president who is dominated by a foreign power. He is told to make decisions to favor some foreign interest. So ganon din ang union. By whatever way, any scheme or any machinations that would deprive the general membership and the union itself from making decisions that are independent. They are being manipulated, dominated, and overwhelmed by a superior power. And that is an unfair labor practice. Or even assisting. When I was vice president of Pepsi Cola, the union came to me and said, "Sir, we will have a general membership meeting this coming Sunday, and we need soft drinks. So we know that you have the authority to sign even 50, 50 na mga kaha, mga cases of soft drinks. Within my authority yan, isang perma." And I said, binasahan ko sila ritong balaod. Gusto ba ninyo mabilanggo ako? Bakit, sir? Nandito pinagbawal yung assisting, giving support to unions. And that is giving support to unions. Any form of support, material, financial, moral, even support in terms of knowledge. We are not supposed, we must have a hands-off policy because kung kamo makautang mo kabubuton sa management, that is the evil so to be avoided by the law. The law does not want you to owe a debt of gratitude to management so that you will fight for the rights and the interest of your members. Kasi kung makautang kayo ng loob sa akin, so, gihunghong lang nila, gihunghong nila, dili ko mahatag ninyo o Pepsi Cola. Pero kasi as official of the company, it will fall within assisting. But I will introduce you to somebody who will contribute to you. O, hindi ako. Kasi pag nanggagaling sa akin yan, that will be assisting. Dahil mga amigo ta, no? Kadaghanan nyo mga Bisaya, tabangan ta mo, pero dili isip nga gikan sa company. Gikan sa atong mga higala nga gusto mo tabang ninyo. Kay kung ang company mo tabang ninyo, may ULP na hinoon ng company. Nasa ka makakita? Where can you find when you are the one helping and at the end of the day, you will be penalized for helping? And that is in the labor code. Initiating, dominating, assisting, and interfering and giving support. No? So tandaan nyo, number 1 si Rick, number 2 si Ida, number 4 pa nga yan eh. Nasa ibabaw si Rick, nasa ibaba si Ida, sa gitna merong yellow dog. Apply ng trabaho, sabi mo, I will hire you but you have to promise that you will not join a union. That is a condition to hiring. Pero pag sinabi lang, I wish na hindi ka mag-union-union, that is not making it a condition. Pero baka it will be interpreted also as interfering, no? So kailangan ang management from the union officials, no? Kailangan merong tinatawag na decent distance, not so close. Kasi sa mata ng mga tao, close masyado yung officer ng union sa management. So, nag-i-interfere na, nagdo-dominate na, nag-a-assist na. Ganun yun. Mag-yellow dog, I will hire you on the condition that you will not join a union. And if you are already a member of a union, you should resign from the union as a condition for hiring. No? Well, ang exception dito, yung mga union security clause, yung close shop. Kasi close shop, we will not give application form if they are not first a member of the union. And that is an exception to the close shop provision. It is coercing an employee to join the union or not, or that is also an interference. But it is not management who decides on the union security clause. It is a provision in the collective bargaining agreement. It is a bilateral agreement between the union representing the bargaining unit and the management representing the company. So, a closed shop, a union shop, is not a form of ULP, although it is interference. See? Ang number 3, uso naman ng contractualisasyon, wa manggid ma-abolish, magamit kag agency kung if you have 100 regular employees and then some of them has retired or retired or were dismissed. So instead na i-fill up mo yung position na bakante, kukuha ka na lang ng agency who magpapadala ng contractual na hindi pwedeng mag-join sa union because they are not employees of the company. And therefore, if that action is proven to be motivated by the objective to coerce or restrain employees in the exercise of the right to self-organization, na parang ginagamit mo ang agency para pahinain ang union. Sabihin, tigas-tigas ng mga ulo nyo, hindi ko kayo bigyan ng overtime. ang ipapa-overtimein ko yung mga contractuals. So kayo, pero yung mga contractual ay araw-araw sila may overtime pa. That is clearly, it can be established res ipsa loquitur. The thing will speak for itself. That the motive behind that is to weaken the union, and that would be restraining the employees in the exercise of their right to self-organization. Are you following me? What I'm telling you?
Yes, USEC.
Yes, USEC.
Okay. Then we go to discrimination. Hindi lahat discrimination ay ULP. Merong discrimination, for instance, discrimination kay siguro na ito ng mga taga-Argao, kay taga-Argao ko, taga-Ronda ko, kanang mga taga-Ronda ato ng siguruhon. Mo na atong pabor discrimination because it has nothing to do with unionism. If the motive of the discrimination is to encourage or discourage membership in the union, that becomes ULP. So do not believe that that all forms of discrimination is ULP. No, huwag yung sabihin discrimination. Dagdagan nyo, discrimination in order to encourage or discourage membership in the union. Huwag nyo kalimutan yung prepositional phrase na in order to encourage or discourage. Kasi pag sinabi rin yung discrimination, hindi kayo bigyan ng complete na score. Because yung very important element is discrimination. Si Mr. Carion ay pinag-initan ng management. Ang management ay si Miss Cora Prijoles. Siya ang manager. Tapos pinag-initan niya ito si Oliver Carion, si Dan, kasi siya ang aktibo sa union eh. Siya ang present witness in my case against the company. Alam mo naman ang mga nangyayari. You have the personal knowledge. So can you testify? Can you execute an affidavit? So si Kukoy bilang kaibigan, and alam naman niya, tama rin naman yung sinabi ni Dan. So he testified in favor of Dan against the company. So nung nalaman ngayon ni Cora yan na ginawa, retaliatory, si Kukoy na naman ngayon ang pinag-initan. Siya na naman ngayon ang dinidiscriminate. Siya na naman ngayon ang tinatanggal. So that kind of dismissal is not only a simple illegal dismissal. It is tainted with unfair labor practice because it is a retaliatory dismissal. It is an act that is designed to retaliate against an adverse testimony against the company. Oh, yan. Number 7, violation of the duty to bargain. What happened to Divine Word University when it failed to respond within 10 calendar days? Or any other forms of violation of the duty like bulwarism, yung mga pinag-aralan nyo na bulwarism galing sa salitang Mr. Bulwer. Si Mr. Bulwer isang executive ng General Motors sa Amerika. Ang style niya ng CBA negotiation is, yes, you have won. Now I am giving you an envelope. This is my offer to you. You demand for 5,000 pesos increase across the board. My offer is only 500. or you leave it. If you take it, we signed a CBA. If you do not agree, then you can go on strike. I don't care. You can go home to your province and plant kamuti. Ganon. Yun ang style. Ang tawag niyan, bulwarism. And that is a violation of the duty to bargain because we have defined the duty to bargain is to sit down with the union, with the intention to negotiate terms and conditions of employment. Kahit hindi mo ibigay, makinig ka. Makipagkita ka. Magtiyaga ka. Hindi yung basta na lang sabihin mo na ayaw ko makipag-meet sa inyo. Ayaw ko yung mga mukha nyo. Ito ang offer ko. Kung gusto nyo, what will happen? Yan ang bulwarism. Pareho ng babae mga ingno ng lalaki, pakasalan mo ako o dili? Parang nananakot pa eh. No? Nananakot, pakasalan mo ako hindi. Bulwarism yan eh. Oh. Bakit hindi niya paliwanag doon sa lalaki? I give you 10 reasons bakit kailangan mo akong pakisalan. Pakinggan mo ako. Tapos nakinig naman yung lalaki. So they are negotiating in good faith. Pero pag sinabi na isa, I don't want to listen. Sawang-sawa na ako. That is bulwarism. That is refusing to negotiate. That is a violation of the duty to bargain. Yan ako. 12 years ako sa San Miguel. Yan ang trabaho ko. Atubang sa union, wala pagyapoy nahimo. Kaya ang demand ng union, kapantay ay langit. Ang offer ko naman, bato sa buhangin. Para makita yung langit at buhangin. Pero nagtawanan pa rin kami. Nagbibiruan pa rin kami. Nag-uusap pa rin kami. Because the duty to bargain does not mean that you are compelled to agree. As long as you sit down, you listen, and you are open to be. But even if it will take 1 year or more, and you have not yet arrived at a settlement, you are still bargaining. It's not the divine word na from the very beginning they refused to meet the union. That was violation of the duty to bargain. No? Ano naman yung paying negotiation fee? Kung ikaw management ka, bakit ka magbigay ng pera sa abogado ng union? That is feather bedding. That is feather bedding kasi ikaw management ka, you do not have an attorney-client relationship with the lawyer of the union. And you, union lawyer, you can be disbarred. And that is a violation of the canons of responsibility because that is conflict of interest. Why are you receiving money from the other side? So even if your intention is pure, that by itself is res ipsa loquitur. That is a sign of betrayal of trust. When you accept money from management, when you are supposed to be fighting for the union, so how can you fight management? How can you bite the hands that feed you? Okay, the last one is violation of CBA, but this has been amended and say only gross violation, not all violation of CBA, because an ordinary violation of CBA is not an unfair labor practice. It is just a violation of the rights of the union and the employees. And that can be remedied through the grievance machinery. And if not corrected through the grievance machinery within 7 calendar days, that dispute should be submitted to voluntary arbitration. Okay, so when we the union, even the unions can be guilty of ULP, and the individual worker is protected not only against the company, but also against the union. The union, which is supposed to be its protector, if the union would exercise any of this act, like coercing an employee, preventing him, restraining him, freedom period na eh. Wala nang union security clause, wala nang union shop eh. So freedom period na at pinipigilan mo pa rin, binubuli mo pa rin yung individual worker na gustong tumiwalag, gustong umalis sa union at sumanib sa ibang union o magtayo ng another union during the freedom period. And if you do that, that is restraint or coercion. And that is committed by the union, by the person who actually did it, or those who authorized it, and lastly, those who ratified it. Mamaya, I will discuss that. Paper bidding, I already told you. Kung ikaw, union president ka, sasabihin sa'yo, para hindi monthly, bigyan kita ng allowance, 30,000 pesos, i-deposit ko sa account mo. Galing sa management yan. Pagka ganun ang nangyari, protection money yun. Parang imbes na ibigay namin sa mga lawyer doon para ipaglaban yung kaso namin, mabuti pa ikaw mismo na tig-file, ikaw na. And that is also feather bidding. And that is the union may lose the license if it is proven that it is committed feather bidding. Kasi ang feather, symbolism yan eh, parang figure of speech yan na panahon sa winter doon sa Canada, doon sa mga malalamig na lugar tulad ng Alaska. So pag nilagyan mo ng feather mo, symbolism na ng pera. Kasi pag may pera, mainit na. Pag walang pera, napakalamig. Alam mo, pag malamig ang relasyon ng dalawang mag-irog, walang bigas, walang pera, nang lalamig ang tiyan. So, paano mo painitin yan? Lagyan mo ng feather at bigyan mo ng feather para uminit ang kanyang kama. O, di ba? Yun ang mga simbolismo dyan eh. So next is to attempt or cause to attempt the employer. Kung ang union mismo ang pupunta sa management, sabihin ng union na, ma'am, yung isang tao dyan na bago lang sa atin, mga 2 years, malapit na ma-expire yung term ko, ang dinig ko na siya daw ang ilaban sa akin. Pwede ba ma'am na ilipat mo yan? Lipat mo yan sa akuan? Sa Hagna, Bohol. Wala bang tayo branch dito dong? Di siya may branch dito. Suroy-suroy lang siya dito. Para dili na niya atong company di sa Mandawi. I-assign mo yan sa Hagna. So that is the union causing or attempting to cause the employer to discriminate against an employee, parang dalawa ng malalakas na power. Nagsabwatan yung union at management laban sa individual. And when the state affords full protection to labor, that is precisely a situation that an individual worker is subject to the union confederating and collaborating, exercising their superior power, their connections, their superior knowledge against an individual worker. And the state is mandated to afford full protection. And this law on unfair labor practice is a very strong protection by the state. Hindi pa ninyo maintindihan yung diniin ko na talaga yun. Asking or accepting negotiation fee or attorney's fees. Can you imagine yung union ang manghingi sa management? Tapos, pati yung abogado ng union, pababayaran sa management. Yan ang daming huda. Nagtaksil, nagbudhi. Kanang mga tao mabudhion, mga tao treacherous. Yan, pareho yan ang kani. Si Julius Caesar na gidunggab ni Brutus, na amigo makay na sila. Kaingon si Julius Caesar na ang pinakasakit nga dunggab gikan. Kaya yung iba madunggab na ako kay mga kontra ginaan ako sa politika. Sa Roman Senate pa nahitabo na gidunggab ni Brutus si Julius Caesar. Ganon din ang nangyari dito sa unfair labor practice. No? That's why the law, in order to protect labor, has institutionalized this legal provisions that condemns unfair labor practice not only as a violation of rights, of labor rights, but it is a violation of the Constitution, it is a violation of the civil rights of the employees and the management. It is also a violation of the labor code as well as the penal code, civil code, penal code, by unfair labor practice. And who are guilty? Ito ngayon, sa Article 249 na ngayon ay kuan na, 251, those who actually participated, principal by direct participation. Those who authorize, principal by inducement or by induction. They are all guilty. And what is the penalty? Maliit lang penalty. Ay, kay, alam mo, kaya yung 1,000 pesos sa 1974, that is already $500 US. So yung 10,000 pesos, that is 5,000 US because 2 pesos lang eh. Ang dollar noong 1974 eh. 2 pesos lang. Tapos may imprisonment or period, hindi yan perspective. Prescriptive period is 1 year from the accrual. And then we have a conflict of laws principles here that you cannot recover damage under the labor code if you have already recovered under the civil code. And before you prosecute, if it is a criminal offense, you can prosecute. But before you can prosecute and go to the prosecutor's office, you have to obtain a final judgment in the labor case. So that will mean so many years. Can you imagine? You file before the labor arbiter, NLRC, Court of Appeal, Supreme Court. Then after the Supreme Court shall have pronounced final judgment adjudging unfair labor practice, then that is the time that prosecution by asking the prosecutor to file an information against the accused. That is a very impractical law. So when you obtain already a final judgment in the labor tribunals affirmed by the Court of Appeals and the Supreme Court, all the evidence that you have submitted there automatically the evidence in the criminal proceedings. You have to testify again. You ask the witness to testify again. You cannot just say, Your Honor, I adopt all the transcript of stenographic notes in the hearing before the labor arbiter as our evidence in this criminal prosecution. That cannot stand. You have to go back to square one. Present your witness. Offer of your evidence as if you begin from the beginning. That is the problem with ULP. So we will now go to some cases, and one of this is this case, which is Shoplifters Corporation. Meron palang company na Shoplifters. Sino nagpangalan itong company na ito? Na merong nagtayo ng union doon. This is in Subic. Tapos itong management, ang ginawa ng management, on the day that there was certification election, binigyan ng pera mga union members, and they were asked to di matuloy ng eleksyon, walay quorum, ang mga karamihan ng mga empleyado, binigyan ng pera, libre ng transportation, libreng pagkain, pangadto mo sa dito, pangaligo mo. So, di matuloy yung certification election. Nya kaning mga opisyal, no, 17 employees, gipa ay na hinuunog pag-clean sa mga grasses sa bundok, no? So itong kaso na ito ay clear cases of unfair labor practice. This is in Zambales, kaya Region 3 ito eh. On October 10, 2004, the company sponsored a field trip to Iba, Zambales. And the union officers and members were sa union ang binigyan niya ng trip. No? Pero part sila sa bargaining unit. Bubuto sana yon. Uncounted sila for purposes of quorum. So, this act of management, no, na pati yung mga opisyal nire-retrench. Kayo pala mga opisyal, sila ang nire-retrench. No? So, the labor arbiter, siguro kaibigan ng ng workers, dinismiss ng labor arbiter. Pero pagdating sa Nielsen, ni-reverse yung decision. And the arbiter they were ordered to pay each of the complainant the following: moral damages, exemplary, attorney's fees, plus all the other remedies. And the Court of Appeals affirmed the decision of the NLRC. And the Supreme Court affirmed the decision of the Court of Appeals and the NLRC. Management was guilty of ULP. So yes, the Supreme Court declared that management was guilty of unfair labor practice. They were asked to pay damages, both moral and exemplary, plus attorney's fees, because they have interfered in the exercise of the right to self-organization. They have contracted out services in order to encourage or discourage membership of the union, and they discriminated, no? And the motive behind the discrimination is precisely to encourage or discourage membership in the labor organization. In this case, explain the concept of the unfair labor practice, which I have explained to you, that it is a violation of constitutional right. It is inimical to the interest of labor and management. It violates the rights to bargain in an atmosphere of freedom and mutual respect. It disrupts industrial peace and stable labor management relations. In essence, ULP related to the commission of acts that transgress on the workers' right to organize. And that is really the virus of ULP, attacking the vital organ of the right to self-organization, as enshrined in the Constitution and as declared by the fundamental state policy. And management was guilty of interference, no? Interference, because it can be inferred, the inference, it can be inferred from the very act of management that its motive, no, it's very hard to prove motive, but the acts by inference can be interpreted precisely to assault, to attack, to violate the right to self-organization. The Employers Act were reasonably inferred as acts of ULP. So this is the so-called reasonable inference rule. If you are asked, how do you know that an act committed by the employer, you would say that in the light of the provision of the Labor Code, Article 248, which is now Article 259, and based on the evidence submitted, if it can be reasonably inferred, if there can be a reasonable inference that such an intent to interfere in the right to self-organization, or restrain or coerce, or discriminate. And it can be inferred that the motive behind is to discourage membership in the union, then the examinee submit be reasonably inferred as an act of unfair labor practice. Ang importante dito, magaling talaga kayo salita na isulat ninyo. Yung the way you argue. The way you argue, and I always tell you that you must always invoke the law. If you cannot memorize the according to the law on unfair labor practice as provided in Book 5 of the Labor Code, It is a form of ULP to restrain, interfere, and coerce employees in the right to self-organization. That is your major premise. Then the minor premise, in the case at bar, comma, it is clear that the performing acts that can be reasonably inferred as an act of interference. Therefore, the examinee submits. So, there is a major premise, the law, there is a minor premise, the facts, and then you make a conclusion. And your conclusion ay logical. When do you know that your conclusion is logical? When law and the minor premise, which is the facts, your conclusion has a legal and a factual basis. So how can you make a conclusion in the bar if you do not have a very strong factual legal basis? And that is the number one reason why you are being tested. So that the examiner will know that you know the law. Kung mag-istorya ka lang dito, wala kay gibarugan basis. Where can you anchor your answer? Where can you base your anchor? Para bang haligi nga imog yung gilubong butangan og semento, bugat kayo ang gibarugan nimo. Ang gibarugan nimo lig-on kayo. Ang imong barugan nga lig-on ang balaod. Maari lang ang wording yun, masayt yun ang wording. Mao na pinaka-solid nga foundation sa answer mo. Then, i-invoke mo yung facts. No? Having stated the law and the facts, you make a conclusion. Nako, paano pa kayo bumagsak pagka ganun ang style niyo? You must always have a basis. In the case of Zambrano versus Philippine Carpet Manufacturing. This is a case of ULP. And the Supreme Court said that he who alleges unfair labor practice must bear the burden of proof. So, sa illegal dismissal, ang burden of proof na sa employer. Pero dito, that is the union and the employee. So, if you charge management of any of the acts enumerated by law, you have to present substantial evidence, whether it is oral, testimonial, or it is documentary, or it is an object evidence or a real evidence. Because absent any evidence, an accusation. So here in this case, the complainants, the union, and the employees were saying that management was guilty of ULP, that they were not able to present substantial evidence. What is substantial evidence? That is that quantum of proof which are to support a logical conclusion. No? Quantum of relevant proof which a reasonable mind would accept as adequate or sufficient to support a logical conclusion. Madali lang sabihin yun eh. Pero kung Paul dyan eh. No? how to know how to determine substantial evidence. Dito kasi nagkaroon ng retrenchment sa Philippine Carpet because of financial reason. And then nagkataon na naapektuhan pati mga union officer. So they were saying that this is an unfair labor practice because the company terminated the service. They were not singled out. There was a criteria that is used like last in, first out. Your being a union officer or a union member does not give you a special treatment that you will be exempted if there is a reduction of personnel based on criteria like last in, first officer ka pa, matatanggal ka. Because that was a valid exercise of management prerogative for retrenchment, which is dictated by financial difficulties. And as a defense for the life of the company. Parang barko yan, malapit ng lumubog, kaya itatapo na yung iba eh. Kasi ang tawag niyan, jettison eh. Yeah, some of the employees are jettisoned, and to choose, there must be an objective and reasonable criteria that is universally used. Otherwise, if there is no criteria, the decision of management would be arbitrary and discriminatory. That is why the presence of a criteria that the exercise of management prerogative would not be tainted with whimsical and capricious exercise of a right. Just because you have a right does not mean that you can exercise that right recklessly. No? You have the right to swing your arms, but the moment you hit my nose, then I have a cause of action. Sic oteri tuo ut alienum non laidas. So use your right in a manner that does not violate the rights of others. Here, the Supreme Court did not see any whimsical capricious. There was no grave abuse of discretion. On the contrary, the employee in making sure that their decision can stand the test of a judicial scrutiny. Ito na, General Milling Corporation. Ito yung sinasabi ko sa inyo eh. Alam naman nyo, General Milling eh. No? The law mandates a 5-year term of the CBA. So, itong 5-year term ng CBA, after 3 years, mag-expire na yung economic letter of demand. Parang kuwanto eh. Parang divine word. Pero ang divine word kasi, it was not a renewal. It was really the first CBA. Ito sa General Milling, renewal na ito eh. So, imbes na sumagot sila, hindi man nagpadala ng letter ang management to acknowledge that they have received the letter. Dito, araw-araw, ang daming nagre-resign sa union. No? And ito, yung reasonable inference rule, sino ba itong nagpakulo? Bakit nagre-resign itong mga union? And the evidence in this case indicated that it was instigated by managerial employees. As doing that upon the instigation of the owners or the top management. So it was obvious that General Milling Corporation had no valid reason to refuse to negotiate in good faith with the union. For refusing to send a counter proposal to bargain anew on the economic terms of the CBA, the company committed unfair labor practice. And again, the reasonable effect rule was used by the Supreme Court and the totality of impact rule. In other words, when you consider the consequences an act, it means that the salary increase of the union are delayed. There was disruption of harmony inside the company. And what was the proximate cause of that? It is the series of acts committed by management which could be reasonably inferred as refusing to bargain, which the law very clearly enumerates as one of the unfair labor practices. Only management violated its duty to bargain. The union was doing its duty. It sent the package of proposals, the notice of intent to negotiate. But the company that was considered by the Supreme Court as a clear refusal to bargain, violation of the duty to bargain, which is an unfair labor practice. So, alam naman natin ang procedure eh. Ang procedure, alam na natin. And presently, it is Article 261. So, if the company does not cooperate, because how can you negotiate if you are alone? The other party does not respond. Parang kahit sa romansa, ikaw lang ang nagro-romansa. Ang niro-romansa mo parang patay. Hindi man lumalaban. So, anong klase yan? That is a refusal to negotiate. No? That is a violation of the duty to bargain. No? Kailangan meron talagang there is an aggression, there must be a retaliation. Ganon yun. Hindi pwedeng isang party lang. It takes two to tango. May failure to send a counter proposal is in. Meron ba malinaw dyan? Q-Cloy versus NLRC. Ito yung Sweden na ice cream eh. Pag-aari ng Chinese na ayaw talaga ng humarap sa union eh. So, yan ang original. Bago mag-Divine Word University, Q-Cloy mo na. That is really the landmark precedent. Yan. Pangalawa, Divine Word University. So, in the bar examination, if you come across with a problem where it is shown that management is refusing to negotiate, then you remember Q-Cloy, Divine Word University, General Milling. Kasi pag ang answer ninyo doon, nag-umpisa, according to the Supreme Court in the case of Divine Word versus Secretary of Labor, in the case of, and also in the case of General Milling Corporation versus NLRC, nako, doon pa lang sa percentage. Therefore, the any submits that is guilty of unfair labor practice. As decided by the Supreme Court in the case of Divine Word University versus Secretary of Labor, General Mailing Corporation versus NLRC. The failure to submit reply this case is an act of unfair labor practice. Grabe, no? Kailangan talaga your answer will sound very logical, convincing, persuasive, with very clear legal basis. So dalawa na tayong panalo ang union eh. No? Yung una, yung sa Shoplifters sa Zambales. Pangalawa, general mailing. Pero nadawa na rin yung sa Philippine Carpet at saka ito, Coca-Cola. In the case of Coca-Cola, management was not guilty of ULP. The union failed to prove ULP. And ladies and gentlemen, talking about Coca-Cola, you know, there is a case which is entitled Cebu Royal Plant. Kasi ang planta ng Coca-Cola sa Mandawi, tinatawag na Cebu Royal Plant. Kasi nung araw kasi yung Royal True Orange kalaban ng Mirinda eh. Kaya union versus Coca-Cola Bottlers Philippine Inc. Ganon, yun ang title eh. Kasi the facts of the case are as follows. For 20 years or more, the employees in the bottling line of Coca-Cola in Mandawi, they were provided seats. No? Pag binantayan nila yung umiikot ng mga botelya para for quality control, walang nakapasok na mga foreign elements. Mga 20 sila eh. 20 sila sa isang linya. 20 din doon sa isang linya. Dalawang linya eh. Dalawang bottling line kasi ang lakas ng sales ng Coca-Cola. So dalawang linya, 24 hours, panggabi sila. So nilagyan sila ng upuan. Eh nung nagbago ang management sa head office, meron silang scientific study na it is not healthy for the employees to be sitting down because they will fall asleep. And when they fall asleep, it endangers their life and limb because they are operating a machine which is moving. So ang nawa ng management, tinanggal yung mga upuan, mga bangkito. Pero mo naman mag-duty ka, graveyard shift. Sobra ng 8 hours eh. May overtime pa eh. Pero ang maganda doon sa Cebu Royal Plant kasi every 2 hours they are given break 30 minutes. Pahinga muna kayo. Pahinga kayo. Magkuhan kayo, magkape kayo. Ayan, 30 minutes. After 30, balik na naman. Tapos later on, ginawa na yung every so dinagdagan tapos ang break tinaasan. Pero nagreklamo pa rin ang union kasi nung kinuha yung upuan, ang sabi nila that was a diminution of benefit. And that is an act of unfair labor practice because the union was not consulted. No? Saan kaya tumama doon sa kwan? Sa mga enumeration ng ULP yung sinabi nila. Wala namang sinabi doon na diminution of benefit is ULP. So, of course, itong mga arbitrator, no, na mga tatlong arbitrator, they decided in favor of the union. Inorderan yung Cebu Royal Plant to ibalik yung mga bangkito because that is a benefit and you diminish their benefit. Ni-reverse ng Court of Appeal. Sabi niya that is not a benefit because a benefit can be translated into monetary terms. Paano mo ma-translate monetary terms yung mga bangkito? So, talo na sa appeal, natalo yung union. Tapos, sila ngayon yung nag-petition to the Supreme Court, Rule 45. And so, the Supreme Court affirmed practice because the right to self-organization is not being attacked. In other words, the very nature of ULP, it is an assault against the right to self-organization. Eh, nasaan ang assault yan? Na lahat naman tinanggalan eh. So at the end, sabi ng Supreme Court, this is a valid exercise of management prerogative. Pasalamat kayo sa management, tinaasan yung break period ninyo. Tapos that use of that sitting equipment is not a benefit in the eyes of the law. Nothing is diminished. That is a valid exercise. So then, sa Coca-Cola sa San Fernando, Pampanga, nagkaroon ng redundancy program. And then, just because they are officer and they are alleging that they were precisely dismissed because of their union activities. But there were many others who were not union officers who were also affected. So here, the Supreme Court upheld the validity of the redundancy program. Dismiss the case of unfair labor practice. So, ladies and gentlemen, after ULP, our next topic is the right to strike. And the right to strike, in the words of Justice Artemio Panganiban, in the case of UST Faculty Union versus University, the ponente, Justice Artemio Panganiban, began the decision by saying, there is a right way to do the right thing at the right time for the right reason to be done by the right parties. So, the right to strike should be done in a right way, in a right manner, proper place, and the right party. Because only a union can strike. Employees who are not organized as union cannot strike because the right to strike is vested on the union. One of the requirements for validity of a strike is that it must be done, if it is ULP, it must be done by a legitimate labor organization. If it is deadlock, it must be done by the union that has been certified as the sole and exclusive bargaining agent. So, that is my introduction for the next meeting. And I hope that tonight you learned from me. I have always tried to come to you prepared, despite the fact that I am writing many books, and I have many consultations with clients, all by Zoom. I am very busy. For my age, I am the most active senior I will never stop teaching until I die. So is there any question? Oh, did you learn anything
Yes.
tonight?
Very well.
So we will now have our picture taking. Please open your window.